Good evening, everyone. So today we have topic will. Will is the one of the most important thing that we are aware. We heard something, but we never taken action about will wasiyat. We have heard. हाँ कहीं we have a study at net. Someone has told me, someone has given the story of कि वो particular बंदा वो हमारे मोहल्ला में था. He was in my city and he their son or their daughters, their kids are the fighting for the property of each other, and they have wasted 4 years, 5 years. So there are the various kind of the story, facts, myth we are hearing. So today we are going to discuss about the some myth. Okay, what kind of the myth is available related to will? There is the one kind of the myth is लोगों के बीच में है कि इफ आई विल राइट विल तो मैं जल्दी मर जाऊंगा. रीजन इज दैट कि विल इज द वन इंस्ट्रूमेंट दैट बिकम द इफेक्टिव आफ्टर माय डेथ, आफ्टर दैट पर्टिकुलर पर्सन डेथ. तो इट मीन्स कि आई एम राइटिंग अबाउट माई विल, आई एम राइटिंग अबाउट माई डेथ कि भैया मैं मरूंगा तो ये चीज होगा. तो इट इज द मिसपरसेप्शन, मिसकॉन्सेप्ट एमंग द पब्लिक कि भैया अगर मैं लिखता हूं तो मैं जल्दी ऊपर चला जाऊंगा. तो देर इज द सच काइंड ऑफ द मिथ. देर इज द वन मोर मिथ इज दैट कि whether will has to registered or not. There is the such kind of the myth is कि uh, once I have created will, so whether I can amend, redraft or not. So there are various kind of the myth. So today we will discuss only about the myth. कि what kind of the myth is coming in the society related to will. And suppose that I'm discussing with you 4 to 5 myths for the today's session. And after it, if your myth is not connected, if your myth is not solved, then definitely you are the free to ask your question. So let me start. And after the end of the session, if your myth is still alive, then you can ask to me. So there is some frequent asked question like one question, or you can say the one myth is कि only registered will is valid. There is another kind of the myth of frequent asked question is that कि once I have created will, so can I amend or redraft or not? I have one child, so what is the need of will? How will can we challenge? And again, in the some other word, it is the first related to the first word, which is the best will, like notary will, registered will, or etc. Can I write joint will, like we purchase the property in name of the husband, wife, mother, son, son, father? So that is the joint property. So whether we can write joint property or not. What is the situation? Once we have created will, so I have to disclose or not? मैं सेक्रेट प्लेस पर रखूं कि नहीं रखूं. ठीक है. सम पर्सन इज सेइंग कि आई हैव टू सन एंड आई वांट टू गिव द सन वन 30% एंड सन टू 70%. ओके. एंड देर इज द सम फियर इनसाइड मी कि अगर ये बात मैं दोनों बेटों को बता दूंगा तो दोनों में लड़ाई हो जाएगी. एग्री हो जाएगी. लेकिन क्या आपके मरने के बाद, मेरे मरने के बाद, इफ माई बोथ सन विल अंडरस्टैंड, विल अवेयर कि एक को 70 मिल रहा है, एक को 30 मिल रहा है, तो क्या वो लड़ाई नहीं लड़ेंगे? एटलीस्ट इफ आई एम द alive, so I can try to solve that dispute. लेकिन once I am not in world, I am not in existence on earth, so who can try to solve that dispute? And in the today's scenario, everyone is interested to have enjoy the other dispute. Like मेरे बच्चे के dispute होगा तो मेरे family, मेरे रिश्तेदार, मेरे दोस्त, they will enjoy. So it is the best thing कि if there is a some dispute, there is a some issue, so it is the best thing कि I have to solve. If I am thinking कि मेरे जाने के बाद ये डिस्प्यूट हो तो बच्चा लोग समझ लेगा कैसे. तो व्हेन वट एवर द फियर इज कमिंग इनसाइड मी कि मेरे जीते जी डिस्प्यूट हो सकता है, तो मेरे जाने के बाद नहीं होगा क्या? तो दैट इज द बेस्ट थिंग कि वी हैव टू डिस्क्लोज. नो दैट आई थिंक. ठीक है. There is the one more myth कि if there is the some properties coming from my father, grandfather, great great grandfather, मतलब you can say the पुश्तैनी property, paternal property, तो whether I can will or not. There is a such kind of the myth कि whatever the property, paternal property is coming, so that only transfer to my kids, my next generation. I cannot donate to someone else, or I cannot give the whole right to other than my kids. Okay. And there is the such kind. can I have the two will? Suppose that I have two son. Okay, I have two son. Yeah, I have the five property. Can I write the five will, and I have to join the all will, etc. There are the lots of things. So let us start. Let me try to cover some myth of related to will, and let me try कि I can solve your all question. So there is the two topic. One is the family succession plan, and another is the business succession plan. So just I am giving the one example to you. Suppose that myself, Manish Kumar Sinha, is the business owner, and I have the manufacturing company where my turnover is the 10 CR, or you can say the 15 CR. Okay. My business in the last 10 years, approx my turnover is going to the 10 CR, 15 CR. Okay. So there is the one thing, and from that manufacturing company, I am drawing my salary. My business is the private limited company, and I'm drawing the salary from my private limited company, and the factory where my business is working. My factory is producing the goods. That is my personal capacity. That land is the personal capacity. Okay, and I have created factory on that particular land, or I am earning rent from that property. Okay, so business is running in that land, like in land in name of myself. So what I'm doing, I'm getting the rent. So there is the two kind of the income. One business income, that is the 10 crore turnover, 15 crore turnover, and after all expenditures, suppose that I have the total profit in a year, 1 year. And again, I'm getting the some salary rental income. So suppose that I'm getting the salary rental income, etc., 2 lakh rupees per month. So in a total, I have the 24 lakh rupees in my hand. That is my personal income, and 1 lakh, 1 crore as a business profit in private limited company. So whatever plan I will do for the succession plan related to business, so that will be considered as the business plan. Like I have two sons. I have two sons. One son is interested in playing cricket, playing racket, playing tennis. Okay, he's not interested in business. My another son, he is interested in business, and he want to do business with me. Okay, so whether it is a good idea to include that my son who is interested in sports? No. If he will come in business, so my business will not survive. Might be possible he will not take the good decision. But my another son who is interested in business, so then he can take the best decision. Okay. And whatever I have the personal property, like in the last 10 years, I'm getting the 20 lakh rupees per month, per annum, salary, interest, rent from my business. So my personal property is around 5 crore, or my business turnover is the 10 crore. So if I'm making the honor in the business, my second son, and in my personal property, I'm giving the equal amount to my both son. So personal wealth का planning करना, that is called the family succession plan. And making the plan for the business, कि मेरा बिजनेस कौन रन करेगा, हु विल रन, एंड उसका प्रॉफिट किसको किसको जाएगा, हाउ इट विल बी डन. तो दैट इज कॉल्ड द बिजनेस सक्सेशन प्लान. तो देयर इज द टू टर्म: business succession plan, family succession plan. The family succession plan is the will you can do for the will, and business succession plan you can go for the trust, etc., all those things. So there is the two topic: business succession plan and family succession plan. Now, I hope I have tried to clear your. Now, will. What is the will? Will is the instrument where you distribute all your wealth, all your asset within your family members. So, what is the legal definition? Legal declaration a person makes about the way they want their property managed or distributed after their death. It means anyone who is interested, whatever I have the property like 1 CR, 2 CR, 5 CR, 10 CR, and I want to distribute to my spouse, to my kids, to my sibling, to my parent. Whatever the way, suppose that my parent is alive and my parent is not earning, so I want to give at least 10%, or I want to write ki, due to any reason, if I'm not alive, but my parent is alive, so I want to create a fund, or I want to make sure कि once I'm not in world, I'm not existence. Okay, even my parent will be taken care by someone else. Okay, so that is the will. So that it is a legal declaration where person makes the way कि जहां पर whatever I have the property, whatever I have the will, so that will be managed or distributed after me, because will is the instrument that become the effective after my death. Before that, suppose that I have written if this property will transfer to the government of India, or this property is given to the hospital to run the hospital, okay, each and everything I have written. But if I'm alive, this will have nothing meaning. But once I'm not in world, then this instrument will come in effect. So uh, during the life, there is no meaning of will. Huh, you can write it is a valid document, but it will be enforceable once I will be not involved. So that we have to understand ki what is the meaning of will. So I hope you got my point now. Before moving to some more thing, so there is a two book that is available on the Amazon. That is the both books is related to income tax, how you can handle, how you can there is a some myth in the income tax also. Okay, I am earning, suppose that I am into job. So I am doing job, my employer is deducting TDS. So why, what is the reason why I will file the return? So, and even someone is saying ki, some person they are earning, they are the in job, and he has transferred 5 lakhs, 10 lakhs, or whatever the money to their spouse. And his spouse has invested in the fixed deposit. And wife is getting some interest. So why I will file return? Reason is that my income is less than 2,50,000 rupees. So that kind of the, that we are discussing about the myth of will. Okay, that is we are discussing myth of will. So that is the, there is the some myth in the income tax. So that all kind of the myth will be solved in this particular book. Okay, and now whatever that session I am taking, to this book decoding will, so where I have written each and everything related to will. And this book is coming in the November 2025. Most probably on 23rd or 25 I will launch, and this again this will be available online and the PDF format, each and everything. And printing, it is the I am discussing with the some printer, and might be possible in the month of the December it will be the available. Now, so there is the one will, one myth. What to do property for the India and outside India? Suppose that I am the Mr. A and I have the property in India, as well as I have the property in Australia, USA. Let's say I have the three property in India and one property in London. So whether I have to write one will, I have to write two will, and what I have to do. So there is the one myth. Ki I have the property inside India, outside India. Then answer is that we have to create two will, one for the Indian asset and one for the another outside India. And suppose that outside India, I have the one property in Dubai, I have the one property in England, and two, three property in India, because most of the time I'm in India. So we have to create three will, one for the India, one for the Dubai, and one for the London. Now you can have the some question, Manish. This is the property in my name, in the name of the Manish Kumar, in the name of the Ram, Shyam, etc. All those things. Why I will create two bill, three bill? Because all belongs to me. Okay, and my kids, he is also in India. So answer is that every country has own succession plan. Every country has their own laws. Okay, so that that's make the compulsory ki you have to write will according to that country. So you have the some property in Dubai, you have the some property in London, UK, United Kingdom, and some property in India. So whatever I'm talking, I'm giving the suggestion to you ki I'm giving the explanation for the Indian company, Indian property, Indian law. So that the UK law or Dubai law has the, they have told कि if you have property in their country, so you have to write and you have to get the registered. In India, you can have the registered, you can have the notary, you can have the plain paper. But in the Dubai, it is the once your will is not registered, then it is not valid. It means कि whatever the bill you have written in India, अब दुबई में तो रजिस्टर नहीं कराओगे, because you have written the in India. So for the Dubai, you have to get the registered. That's why I'm saying ki whatever the location you have the property outside India. In the India, suppose that you have the property in Delhi, uh, Chennai, Bombay, then whole property in within the India, then you need only one bill. But your property outside India, then you have to need at least two bill, one for the India, one for the another outside India. So I hope you got my point. So what was our myth? Myth one, yeah, I have the property in India, outside India. So whether both property will be covered in the single will? No. You have to write at least two will, one for the Indian asset and other for the outside India. There is the another myth कि I can prepare will at the last stage of the life. Suppose that my age is the 44 and I am thinking कि okay, I have to write will, but I will write when my age will be 70, 80, 75, or I will be in the ICU, then I will do. So I want to say only one thing. Death is the certainty, death is the black truth. That is the 100% confirm कि everyone will get death. But when we are not aware. मौत हर किसी को आनी है लेकिन किस दिन आनी है वी आर नॉट अवेयर. तो व्हेन वी आर नॉट अवेयर तो हाउ यू कैन से कि मेरा लास्ट स्टेज कब आएगा. सो वी हैव टू अंडरस्टैंड कि टुडे इज द लास्ट डे एंड वी हैव टू क्रिएट विल. अदरवाइज व्हाट विल हैपन कि इन absence ऑफ द विल वट एवर द my family, my kids will face the legal problem. So once I have not created will, so my spouse, my kids will face the such kind of the legal harassment or etc. That we have seen कि धीरूभाई अंबानी has died without making their succession plan. So after his death, Mukesh Ambani and Anil Ambani were fighting, and though India में everybody was aware that this family is a very good family. Okay, there is no dispute. And after death of the Dhirubhai Ambani, we have found out that they have the dispute. So that we have to understand. So answer is that we have to create now or today because we don't have the opportunity when death or when I will be not in world. So it is the best thing ki if you have not created till date, it's okay. But you have to make the plan and as soon as possible you have to do. Then there is no one myth कि once we have created will, then we cannot amend. एक बार हमने बना दिया, then I cannot amend. Then answer is that will can be amended any number of the time even before last breath of life. It means मैंने 2 महीना पहले एक विल बनाया था और 2 महीना पहले बनाया था तो लेट्स एज्यूम कि 2 महीना पहले 2 मंथ बैक आई हैव क्रिएटेड विल और उस टाइम तक मेरे को नहीं पता था कि मैं एक नई प्रॉपर्टी और परचेज कर लूंगा बट आफ्टर 2 मंथ आई हैव परचेज द न्यू प्रॉपर्टी देन आई हैव टू अमेंड रीजन इज दैट कि माय एसेट हैज बीन इंक्रीज एंड आई वांट टू गिव कि ये असेट जो मैंने न्यू असेट आई हैव परचेज आई वांट टू जस्ट ट्रांसफर टू माय स्पाउस. I want to transfer only to my spouse, not my kids. And I want to make that some conditional कि जब तक मेरी वाइफ जिंदा है this property will belongs to my kids, belongs to my spouse. And after that, this property will transfer once my spouse or I will be not in world. So this property will transfer to my kids. But for the other property, without a spouse, just I want to transfer to my kids. So that we can do. So whenever your asset is increasing or decreasing, suppose that I have written the one will, this property in the ashram will be transferred to my kids, my spouse, and after 6 months I have sold out. So what is the meaning of that will? क्योंकि मैंने तो उस property को ही बेच दिया. Then again I have to make the amendment कि now this property has been sold out and I don't have the legal right on this property, so I cannot will. Okay, so that we have to try. So whenever the family member is increasing, decreasing, or asset is increasing or decreasing, so we have to amend. Like I have mentioned the one in will कि some part of the my property will go to my mother if I am not alive, my parent. Okay, but before me, before going to me, before end of the my life, my mother is passed away. तो डेफिनेटली आई हैव टू अमेंड बिल बिकॉज जब मदर ही नहीं रहे तो व्हाई आई विल make the maintenance amount to my mother. So whatever the situation, your asset is decreasing, your asset is increasing, your family member is decreasing, like decrease can be due to that or increase by way of the worth. Okay, so you have to amend. So that you have to understand कि what you have कि you can amend and there is no such as the number कि एक बार amend कर सकते 2 बार. You can do the 100 times, 200 times, whenever whatever the way you want to do, but every time you have to write in the legal way. और यू हैव टू टेक केयर कि हाँ विटनेस का हमेशा साइन हो, स्टैम्प पेपर पर हो, जो भी हो सही तरीके से लिखा हुआ हो. तो दैट यू हैव टू मेक श्योर. एंड देयर इज द वन ऑफ द बिगेस्ट मिथ इज दैट कि ओनली रजिस्टर्ड विल इज वैलिड. कि जब तक मैं इस विल को रजिस्टर नहीं कराऊंगा तो वेदर इट इज द वैलिड और नॉट. तो दैट इज द वन ऑफ द बेस्ट थिंग कि ये चीज हमें समझना है। तो आंसर इज दैट कि विल इज वैलिड इवन इट इज द रजिस्टर्ड नोटरी प्लेन पेपर और ओरल विल। ओके, तो एक प्लेन पेपर पर भी लिखा हुआ है, इफ इट इज साइंड बाय द टू विटनेस एंड एवरी क्लॉज वट एवर आई हैव रिटेन दैट इज द लीगल। सपोज दैट आई हैव रिटेन द वन विल कि मेरे जाने के बाद मेरा बेटा मेरे पड़ोसी को क्या कहता है, मेरे पड़ोसी को मर्डर कर दे, देन आई विल ट्रांसफर द प्रॉपर्टी टू माय सन, देन इट इज द इलीगल विल। ओके, तो इफ आई एम राइटिंग इन द in legal term and whatever activity, whatever the way I have writing, okay, then it is a considered illegal. If I have written the illegal activity, illegal sense से मैंने बनाया और I have drafted will but no witness is signed, then again it is the invalid will. Okay, or in the will I have written the illegal activity, illegal things, then it is not a valid. So will is the valid even it is the registered, it is the notary, it is the plain paper or the oral will. Might be possible you will think कि once you are talking about the registration, you are talking about the notary. So how it comes the oral will? Oral will is the one thing. Suppose that I'm going on the highway with my family, or I got accident, and due to some reason my family is alive, but there is no chances to survive myself. So then that particular highway, whether I can get notary, whether I can get a registrar, whether I can write anything, no, it is not possible. Then I can try to make whatever the property I have to distribute to my spouse, to my kids, to my parent, to my sibling. Then this will be considered as the oral will. Right now, it is not a concept of the oral will. Reason is that everyone has the mobile phone. So suppose that my family, uh, I'm not in condition, I'm the bad condition and I'm not in condition to survive. But my family, my kids or some other person can have the mobile phone. Then I can request whatever I am speaking, whatever the statement I am giving, you can record one mobile, two mobile, three mobile, and after that, that you can produce in the court. So this statement, this fact can be presented in court and this will be considered as the oral will. So this can be considered as the valid will. So oral will is also valid. But right now, if suppose that I have in front of you, I have managed my property and I am alive, and after 1 year, if you have taken Manish has given the class and he has described and he has given the oral will and I have the recording, and after 1 year, suppose that in the during the session, I have transferred the whole property to you, and you can say कि now it is the recording and money has transferred to me, whether it will be the valid? No, reason is that कि I today I'm providing the oral bill to you, and after 1 year I got the death, और after 1 year I am not alive. तो कोर्ट विल आस्क कि जब इसने ओरल बिल बनाया तो उसके 1 साल के बाद मनीष इज नो मोर, तो 1 साल का टाइम था तो उसने रजिस्टर क्यों नहीं कराया, उसने प्रॉपर्टी क्यों लिखा? हाँ, इफ आई एम गिविंग द ओरल बिल टू यू एंड आफ्टर विद इन द 1 month, विद इन द 5 minutes 10 minutes 1 day आई एम नॉट अलाइव, then court can understand कि हाँ, this is the situation where I can accept the oral bill. So that we have to understand situation condition कि when oral bill is the valid, but oral bill is also valid. Okay, and last one I will discuss before ending of session कि when any family has a big succession plan, they have the more weightage and that will be the safer side. And any family without the succession plan, it is the on the lighter mode. And if we have not created the succession plan, then my family can have the legal harassment, family dispute, family business complexity, and no control over the distribution. And we have found various times कि अगर suppose that we are moving someone somewhere, तो we have seen ये प्रॉपर्टी डिस्प्यूट का है, ये ना कोई खरीदेगा ना बेचेगा, तो देर इज द, तो डिस्प्यूट किस चीज का होता है? डेफिनेटली बिटवीन द ब्रदर, बिटवीन द सन एंड फादर एक्सेट्रा दैट। ऐसा नहीं होगा कि डिस्प्यूट मेरे पड़ोसी से होगा, डिस्प्यूट ऐसा नहीं है कि किसी मेरे किसी दुश्मन से होगा, डिस्प्यूट हमेशा विद इन द फैमिली मेंबर ही होता है। तो दैट इज द लैक ऑफ द सक्सेस, दैट इज द लैक ऑफ द सक्सेसफुल प्लान। तो नाउ इफ यू हैव एनी क्वेश्चन, you have the any with, you have the any doubt in your mind, you are most welcome, and I am here to describe to solve your question. So
Thank you,
Radmin or
Manish.
yeah, Radmin or Mr. Just name is coming double B BB. So if you have any question, please you can.
Rajvin, you have to unmute.
Yeah, Manishji, thank you so much for explaining it so well. I hope we can have part three also for this because will writing is a big topic. Although although I'm not in India, but I totally understand because someday I'm going to get down that road. That's why I am doing as best as I can to leave behind a legacy through writing, through my works, and through everything else. So, so yeah, so yeah, so will writing is something that we cannot we cannot take for granted. But the thing is,
क्या पहले वाला करना?
is so the question I asked you before, I said that is it better to I everybody has a living, everybody has a will before passing away, but when you're still alive, your living will your living will um how do you uh how do you get how do you how do you manage that? In Malaysia is power of attorney. I'm not sure whether it's the same in India. Thank you. Because
हाँ.
because
Eh,
sometimes because sometimes when you explain to the siblings when you are alive, they might not hear you. So maybe living will is the best.
Yeah,
What?
living will is the best, and in India now it is going to started, but it is only related to some critical issues, not in the normal scenario. Suppose that anyone is facing the some medical issues, or he's not able to take the some
Yeah, yeah.
decision related to finance.
Power of attorney and decision making, I'm telling. That's
That
what
I want to say. So suppose that I am the normal I am the normal person. I can take the any kind of the decision. Then this condition will not applicable to me. But anyone who is not who not cannot take the own decision, then it will take. It is the so this concept is the applying, and might be possible within the 3 to 4 years, 5 years. This concept will be again acceptable in India. But now it is not so much. Yeah, it is not so much. Uh, acceptable in India right now.
Yes.
Okay.
Thank you. Yeah, we also have.
Just hold.
So we don't know your name, but I've just spotlighted you if you want to share.
My name is Bimal Batra.
Goodness.
So I have one question.
इसका tax liability.
So I have one like business which is a private limited company, and me and my wife are the only directors in the company, but my children are living overseas. So I have mentioned in my registered will that all the assets of the company will be divided among the children. Like after my demise, it will go to my wife, and after my wife, it goes to the children. So do I have to like make the kids as a shareholder in my company? Will that be easier for them when they are living overseas, or just the will be okay for them?
No. Yeah, so you have the very perfect question. First of all, you have to create the shareholder to your both kids. Reason is that after you and your wife, if no one is
Yep.
alive, so ultimately share of company that belongs to you or your wife will transfer to your kids. So once they will
Yep.
be the owner of company by virtue of the transferring share from you and your wife, then they can easily take the decision related to your business. That business will be run by the some other person, and we will just enjoy the profit, just like the dividend, or they can sold to any other person. Suppose that your business is a very good brand name, so then they can sold like in the 1 CR, 2 CR, 5 CR, whatever the situation, or they can sold the factory, etc., all those things. So asset of the company is nothing. Once you have transfer, you can write कि whole share of the company will be transferred to my both kids equal, or you can give कि 80% to son one and 20% to son two, whatever the way you want to distribute. That
Yeah.
I'm just example. So transferring share or mentioning the about the share of the company, it is the best way. Instead of the making asset of the company, like what will be the asset of the company, like car, like factory asset, some inventory. Okay, sir. So who can take the decision? Director or shareholder? Without permission of the shareholder, whether anyone can sold out the asset of the company? No. The first thing is that you have to create or you have to write in that particular will कि after you and your spouse, your kids will be shareholder. So that is the best situation.
So do you have to make them a director as of now, or just making them
No,
shareholder will be
director right now you can be, because you are the alive, so there is no such as the situation. And in a company act, there is the one provision. If any director has died, then within the 30 days or within the 60 days, another director can come, and that is the you can say the abnormal situation, because nobody is aware ki when I will be not in world. Okay. So company act or MCA provide the some relaxation period 30 days ka. Within the 30 days you can change or you can appoint some other person. So that is the possibility. So there is no need to make the director right now, or even there is no need to mention in a will. For shareholder, there is the need.
So in India, do we like have a option of a having one person as a director? Like in Australia, I understand they give
Yeah,
to
in
one
India,
person.
suppose that in India, uh, if you want to make the director outside India, or there is the shareholder outside India, so there must be one person who is residing in India or resident of India. That is the one compulsory condition.
No, no. My question is like supposing like today we are two directors, and tomorrow if I go, my wife will be the only director. Can she be like managing the affairs with single director?
No, that is not possible in the private limited company. At least you have two director. There is no other way without having two director.
Okay, so in that case, then my kids will be like shareholders. So after my going, my wife has to appoint one of them as a director.
Yeah. Your wife can मतलब कि that particular time your kids can be director, or any employee who is the suppose that you think कि Mr. XYZ and he is the long term, and he is the, you can say the विश्वसनीय है, विश्वास पात्र का है, and he is the honest person, then you can make the director, because making director is not making the shareholder. You can make the director anyone without giving the any single share. So he can be director, so that कि MCF formality will be completed and you can carry on your process.
So director need not be a shareholder in that case.
Yeah, there is no need of the making the shareholder to make director.
And what happens like if it's just hypothetical situation, like if both of us are not there at one particular
Yes, sir.
moment?
That is the possibility. There is the one quote you can search in the Google. Ki company is the company is the perpetual person. Yeah, as you and me, the natural person, the company is the artificial person. It is not a natural person. The natural person can die, but company cannot die. So what's happened? Ki suppose that there is a one company ABC Private Limited, and Mr. A or Mrs. A is the shareholder of that company, and Mr. A and Mrs. A is going the for tour or business meeting, and both got the road accident, and there is no
Yeah.
option, both are the dead.
Yes.
Then share of Mr. A and Mrs. A will transfer to their kids or their legal owner. Okay, legal here. So automatically share will transfer to their kids or someone else who is the related to the family. So so that the company never die.
So in that case, then there'll be they can become directors within 30 days.
Yeah, the
If
board
both of us
director
are
you
not
have to
there.
create, you have to choose. But shareholder, there is no need. Suppose that I have the company, me and my wife is the director and shareholder. So मेरे और मेरे wife के बाद my son will be shareholder, but director might be possible. My son can be or someone else can be, but shareholder my kids will be. It is the confirm.
Okay. Okay, thank you.
Yeah. So whatever you have the question, so you can post your question on uh, uh, WhatsApp, and I will answer. Or even from the WhatsApp, you can get my number, and whatever you have the question, we can discuss, sir.
Okay, thank you. Thank you very much.
Yeah. Thank you, sir.
Thank you so much, Manish. And thank you, everyone. And we'll look forward to see you again tomorrow morning. Thank you.